Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. In this episode, we talk about the Nepal plane crash and why it raises concerns about Nepal's aviation system. We also talk about the Election Commission's plan to introduce remote voting and why political parties are reluctant to support the move. But first, we talk about Jagdeep Dhankar. Since he became the Vice President last year, Dhankar has been criticizing the Supreme Court. And his criticism is about the court striking down the NJAC Act, the National Judicial Appointments Commission Act, which was passed by the Parliament back in 2014. Now, before we go ahead, it's important for us to understand what the NJAC Act was and how judges are appointed right now.
So judicial appointments was sort of the first big policy push that the Modi government tried to bring in when they first came to power in 2014.
That's Apurva Vishwanath. She reports on law for the Indian Express. And she says that it was keeping judicial appointments in mind that the Modi-led government had introduced this amendment.
This amendment was to give the government a foot in the door when it comes to judicial appointments. Like we know, Shashank, in the last 30 years, what we have in place is a collegium system of appointing judges, which the Supreme Court itself has evolved through a series of judgments in which it has basically said that the primacy when it comes to appointments is with the court itself, is with the Chief Justice of India. So the system that we have now is the Chief Justice and his senior most colleagues who form the collegium recommend certain names to the government, and those names that the government is bound to appoint in most cases. Only in exceptional cases, the government can ask for a reconsideration. But the law, that is a third judge's case that was decided in 1998, says after reconsidering, if the Supreme Court Collegium once again feels that somebody should be appointed, the government is bound to appoint.
But it is important to note that the way the collegium system functions is not mentioned in the text of the Constitution. Apurva explains that the Constitution actually gives powers to the executive branch regarding judicial appointments, although it says that it must consult the Chief Justice of India for it.
So this consultation is what the Supreme Court interprets it in a completely different way. And there is a history leading up to this. There is a lot of context as to why this happened. And in 2014, when the Modi government came to power, the steps that they took was to bring this power back to the executive domain. Maybe not entirely, but at least give the executive a foot in the door. So the National Judicial Appointments Committee was supposed to have commission which would also have the Prime Minister and representatives of the government along with the Chief Justice and some other eminent members of the society to recommend names of judges to the higher judiciary.
And this is what the Supreme Court struck down. It said that since the Chief Justice of India would not have a casting vote, this process would be tilted in the favor of the executive and would enable it to veto any name that was proposed. This is what Vice President Jagdeep Dhankar has been criticizing lately, and he even mentioned it in his maiden speech back in December.
The Parliament, in a much-needed historic step, passed the 99th Constitutional Amendment Bill, paving way for the National Judicial Commission. This historic parliamentary mandate was undone by the Supreme Court by a majority of 4:1, finding the same as not being in consonance with the judicially evolved doctrine of basic structure of the Constitution. Honorable members, there is no parallel to such development in democratic history, where a duly legitimized constitutional prescription has been judicially undone. A glaring instance of...
Now let's talk about how the Supreme Court was able to do this. How it was able to strike down an act that was almost unanimously passed by the Parliament. Well, it was able to do that through something called the Doctrine of Basic Structure. In this segment, we speak to Apurva about what this doctrine is.
The Doctrine of Basic Structure is like a judicial review tool that the court uses. So which means any piece of legislation, especially a constitutional amendment, will have to pass the basic structure doctrine, which means that the amendment itself cannot destroy the original structure of the Constitution. So this test was evolved by the Supreme Court in the landmark 1973 Keshwanand Bharti ruling. So this is, a 13-judge bench ruling of the Supreme Court, which had seminal importance, and what culminated into the Keshwanand Bharti ruling itself is also a big part of the judicial and legal history of India. So in this doctrine, what the court does is looks at whether the amendment can have the power to destroy or damage any of the essential features of the Constitution that was envisaged by the framers of our Constitution. But what is basic structure is something that is deliberately left abstract by the court. New features are added and understood, interpreted every time this test is applied. But we know our basic features, right? Like judicial review is considered a basic feature of our Constitution. The rule of law, or having a democracy, being a republic nation, or the spirit of federalism that is in our Constitution. So there are some basic elements which the court has identified, but this is in no way an exhaustive or a definitive list. So every time this test is applied, the court interprets a particular feature of the Constitution and then says whether that's basic or not. But what this test essentially does is it places substantive limits on the power of the parliament to amend the Constitution. So you can amend, you can follow the procedure, but what you can amend and how much you can amend is something that the court will have to ultimately decide.
Right. So Apurva, let's say the parliament, using a constitutional amendment, decides to alter the Constitution in a way that goes against its most basic principles, like representative democracy or even secularism. Then through this basic structure doctrine, the court can basically strike down such an amendment.
Yes, and this is essentially the crux of the debate that led to the court bringing this doctrine in the first place. From 1967 onwards, the judiciary and the parliament during the time of Prime Minister Indira Gandhi was in a series of such debates, and essentially on how much the parliament can amend the Constitution. So one of the things that Indira Gandhi government did was every time there would be a reversal of a key piece of legislation in the Supreme Court, the Parliament would amend the Constitution and remove that effect of the Supreme Court decision at all. The Privy Purse ruling or the bank nationalization case, and significantly the land reforms amendment. So all of this, every time there would be a roadblock in the judiciary, the Parliament would go ahead and amend it. So what happened then was the Parliament also said that the elections of the Prime Minister and President cannot be reviewed by the Supreme Court. That was an amendment that was brought in. The Parliament also said that land reforms itself was not judicially reviewable. The Parliament gave itself vast powers to amend the Constitution. So it was in this context that the Supreme Court in 1973 had to decide how much is okay. Like we know in the land reforms case, the right to property, which was a fundamental right until then, was taken away. So the question really was, if one fundamental right can be taken away, can the Parliament, suppose hypothetically, amend the right to life and personal liberty guaranteed to every citizen and take that away? So it was in that context that the Supreme Court grappled with this issue, and as some legal historians and scholars have put it, as a compromise brought about the basic structure doctrine.
Okay, so through this doctrine, we are treating fundamental rights and the essential principles of the Constitution as so sacrosanct that even a unanimous vote in the Parliament cannot undermine them.
Absolutely. So it is in a sense to curb a majoritarian impulse that the Parliament could have. And of course, a lot of what happened in the post-World War German constitutional context was discussed in the Supreme Court in Keshwanand Bharti judgment. There was a German constitutional scholar, Professor Conrad, who's referenced in the Supreme Court judgment. And the discussion is whether, like Hitler used the emergency powers to alter the Weimar Constitution completely, can we have a situation like that in India? So this was a direct question that the Supreme Court addressed and evolved the basic structure test. But there is a lot of legal scholarship that criticizes the basic structure test as well. Because when you have the Parliament, which represents the will of the people, bring about a law, and sometimes unanimously, right? Like the NJAC constitutional amendment, for that matter, there was only one abstention in the parliament. That was of Ram Jethmalani, who was himself a former law minister and a senior advocate. Except for Mr. Jethmalani, the cutting across party lines, everyone voted unanimously in favor of the amendment. So the question really is the judiciary using a tool to undermine parliamentary supremacy? Are they undermining the powers of the parliament to amend the constitution?
And now one presumes that the vice president knows everything that we have discussed so far. So could you talk about the concerns it raises when someone in his position criticizes the judiciary on this point?
Yes, I mean, reports in our newspaper have also pointed this out, that the BJP, including its tallest leaders like L.K. Advani, were in complete support of the basic structure doctrine and how it is applied by the courts. You look at courts as a neutral arbiter that protects the fundamental features of our constitution and ensures that the constitution is not diluted by any government, no matter how much majority they have in the parliament. So Jagdeep Dhankar's views, and this is not the first time he's talking about this, the NJAC issue or the power of the parliament itself, these are issues that are justiciable in court. If he's speaking for the government, then there is nothing that stops the government from bringing in a second amendment on judicial appointments itself. At that point, then Attorney General Mukul Rohatgi had said that the government has no plans to do that. And there's been a hiatus on the issue of judicial appointments. But his remarks also come at a time when the law minister himself has been making these noises about the legitimacy of the collegium system, about how opaque or non-transparent it is. So in that context, it's troubling because what you have is a constitutional functionary criticizing the court's settled view that has been there for 30 years.
And Apurva, this current controversy, of course, has judicial appointments at the center of it. Because the Supreme Court struck down an act that could have affected them, and it did so using the basic structure doctrine. But the way judges are appointed right now, that system came about after the Keswananda Bharti case. So could you talk about the connection between the two?
Yeah, so the judge who ruled in favor of the government in the Keswananda Bharti ruling was rewarded by the Indira Gandhi government, and which led to several senior judges who were superseded resigning from the court. And, that culminated into how the collegium system of appointing judges came about. Because the judiciary thought that if the government can alter the structure of the court itself, then the powers perhaps should not be with the government. Then the Chief Justice of India should get to decide who is the judge and how he is appointed. So it's in a sense like ironic that the two issues that the Vice President talks about are so interconnected and they have such a history as to why it happened.
And next we talk about the Nepal plane crash. On Sunday, at least 68 people died after Yeti Airlines ATR 72 that took off from Kathmandu crashed in the city of Pokhara in Nepal. Among those who died also included 3 children and 3 infants. Additionally, the plane was also carrying 5 Indians, 4 of whom were friends and had reportedly gone to Nepal to visit the Pashupatinath temple. Now, Yeti Airlines has crashed a number of times in the past as well, and has once again raised alarm bells about the aviation industry in Nepal. For this segment, we spoke to Yubaraj Ghimire yesterday, who joined us on a call from Nepal to talk about the crash. Yubaraj, at the time that we are recording this, it has now been more than 24 hours since the plane crashed. Could you talk about what we know so far about what happened?
Well, there were 72 people on board. That included 4 members of the crew. And 68 bodies have so far been recovered because it's a difficult point where the rescue operation is going on, search and rescue. So they have not been able to trace the other remaining 4 bodies. That's the latest we have. And parallel exercise is on, like bodies recovered are being flown to Kathmandu, some being handed over to their relatives in Pokhara, and some bodies are being transferred to Kathmandu, where they will be handed over to their relatives for their last rites. This is the latest we have. And today, the government it's a national, mourning. It's a public holiday today. It's a rare occasion that the government took this decision.
And right now, do we have any idea about what led to this crash?
No, the black box is yet to be recovered, but from the available accounts, it looks like the aircraft approached from, like unusually from the western side to land in Pokhara. It didn't work. So the experts speculate that there was a balancing between the load and the speed was being difficult. So it didn't land there. It went a bit up, and where it lost its balance and crashed into flames. And it crashed into a river, Seti, which is at places not visible from, outside, almost like an underground river there. So because it fell into the bank or slope of that river, the search and rescue operation became even more difficult.
Right, and the rescue operations are still underway. But now the Yeti Airlines and even its subsidiary, Tara Air, have a history of such incidents. We have seen crashes in 2004, 2006, 2008, 2016 and 19, and this is just Yeti alone. So could you talk a bit about this history, because it has raised concerns in the past as well?
Well, yes, Yeti Airlines and Tara Airlines, a sister organization which is basically domestic airlines, they have a history, unfortunately, of contributing the maximum number of crashes. And also it is in the blacklist of European Union. My information is the European audit team was likely to come here in February to reconsider on the basis of the request made by the airlines to not to, blacklist them. But now with this, I think that is now have become even more difficult. But it is the biggest airlines in the domestic sector. So there are two issues being raised here. One is airworthiness. There is no serious compliance of safety measures, airworthiness of the aircraft. Regular maintenance is not there. Then the regulatory body in Nepal, which is the Civil Aviation Authority, is also the operating agency in Nepal. So there are certain compromises, there are certain irregularities. This is feared here.
Right, the fact that the regulatory authority and the agency that is supposed to be the watchdog is also in charge of operating flights, it does seem odd and very much in conflict of interest.
Precisely. And also we really don't know the, regular training, how trained the pilots are. There have been no systematic kind of explanation from the private airlines operators on availability of qualified pilots, on what kind of condition do they work and all that. We don't know.
And in the past, when such crashes have taken place, what sort of steps have been taken to address some of these underlying problems?
Unfortunately, not very serious measures have been taken. In the past, wherever fatal accidents have taken place, and the government has been ordering a mandatory investigation, in which in more than 90% of the cases, they have blamed human error, meaning blaming pilots. But experts I've spoken to, they don't agree with this. That cannot be the only cause for that. You just put the blame on the person dead and gone and you forget about it again. That's why accidents are recurring.
Right, so you put the entire blame on one person, so no big systematic changes are able to take place.
No systematic changes. No. Although there has been upgradation of air traffic, system, it is not like what it used to be 20 years ago. They have modern tower system, air traffic system. Control tower is effective. Even there, in the case of this ATR yesterday, it was in contact with the air tower until 10:55, just 2 minutes before it crashed. So there could be many other reasons, but we really don't know the condition of the aircraft, its engine conditions and all that. But basic issue is, why is there no airworthiness examinations regularly and in required frequency, whether C checks are taking place regularly, and why is this demand from many passenger bodies and travelers and airlines and experts that it shouldn't be the monopoly of the Civil Aviation Authority to operate and regulate the bodies should be changed. They are not, addressing these issues. So it also, in a way, smacks of some kind of corruption.
And you mentioned that there has been a day of mourning in Nepal. So how are people there reacting to this incident, especially since there have been such crashes in the past as well?
Well, it came like a real shock yesterday because it was a big festival in Makar Sankranti. People observed this festival in different forms, different names in Magi and all over the country, like in Pokhara also. But then suddenly, when a prime minister was to participate there, other ministers were to participate in that kind of function, in that celebration, the news comes that, 68 people at least, they have lost their lives, that this is the biggest accident in terms of the loss of life in Nepal in domestic sector. It was really shocking and people are alarmed, outraged and angry why this happened.
And next we talk about the Election Commission, or the EC, the autonomous body in charge of conducting free and fair elections in the country. The EC has been looking to start remote voting, a process through which domestic migrants would be able to vote for their home constituencies from polling stations in the cities they work in. And for this, the EC will be using remote voting machines. In this segment, we speak to Indian Express's Damini Nath about these plans and why no political party is supporting this idea. Damini, could you talk about why the Election Commission has been pushing for remote voting?
Right. So the Election Commission feels that the voter turnout has been stagnating. In the last 3 general elections, about 30% of the registered voters decided not to cast their votes. So in December, the Election Commission wrote to political parties and explained its plan. And in that, it said that the fact that 30 crore electors were choosing not to exercise their franchise was a big concern. So there are many reasons for this, that 30 crore voters are not voting. The EC thinks internal migration may be playing a role. Many electors are living outside their home constituency for work and may not want to shift their voter ID to their new address, maybe because it's a temporary address, or they may want to retain their voter ID as a form of address proof.
And does the EC know how many of these 30 crore voters are those who are not able to vote because they don't work in their home constituencies?
So no, the EC itself admits that there is no database of migrant workers. It admits that this is one of the issues that needs to be addressed. They don't know how many of these 30 crore are actually not voting because they're unable to go back to their home constituencies.
And right now, do we know how this remote voting will be conducted?
Right. So the EC has in its concept note, given how this would work. Basically, remote voters will have to first pre-register by applying to the returning officer of their home constituency. Then remote polling stations would be set up at locations outside that constituency, depending on how many remote voters sign up. And the Electronics Corporation of India has developed something called a remote voting machine, which is a modified version of the EVM. This machine will have the ability to cater to 72 constituencies at once. The voter will be able to use a special constituency code and then be able to see candidates for their constituency, and then they can cast their vote.
And the EC was supposed to hold a demonstration regarding this. Do we know how that turned out?
Right. So there was supposed to be a demonstration on Monday. The Election Commission had called all national and state registered parties for a meeting to discuss remote voting and to see this RVM in action. However, nearly all the parties opposed this idea and they never got to the demonstration.
And what is the reason that nearly all political parties are not willing to support this initiative?
So most of the political parties have a very basic problem with this idea, that how would a migrant voter be defined? So the first question is, who would be a migrant voter? Would it be somebody who is traveling outside their home constituency for 6 months or a year or longer? The second issue that they have is, how would the election campaign work out in a remote location? For instance, how would the model code of conduct be implemented in a city when the elections are happening in a state which is really far away? How would the EC ensure that the elections are free and fair and that the remote voter is not getting influenced at all?
And has the EC responded to any of these concerns?
So the Election Commission has not yet responded to any of these issues. They had a meeting with political parties today, and what EC sources are saying is that they will have further in-depth discussions, and they've asked political parties to send in their written feedback, and they've given them more time to do so.
You were listening to Three Things by the Indian Express, Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.